Yes.
I don't know.
One matter we have to pronounce judgment, na?
Hello, can I make a mention?
Yes, mentioning it. Yes. Sorry.
Beg pardon to mention, sir. Let's say Matta 351 of 26. Last week it was listed on 23rd of June 20.
What you want?
Let's say this matter may be listed.
Last week of August. Last week of August. Give.
Okay.
Give all your memos. Our court officer will look into and post them. Posting matter. Just look into. Let them not cluster. Next,
Item number 42.
So, one second. Yes, brother.
This matter was before.
Give. Don't waste the morning time. Is very precious for us, for everybody. Because sun is going down thereafter. Yes.
Item number 42. This is an old matter, also may not likely to reach since your lordship is rising at 3.
That's true.
But yet I will pray that I am respondent. Maybe called on after 4 weeks sometime.
After 4 weeks.
Sometime after 4 weeks. Because of my personal difficulty.
Okay. 4 weeks we will not give you. 2 weeks we will grant. Kindly be ready by that time.
Now, I will not have mentioned, but there is some difficulty which I am not able to say in the court. But
is it?
There is some.
Then choose a date.
Any day after 4 weeks. After August 15.
Well, after August 21, after 21st. All right.
It's item 39.
Finally, at the request of.
Both my lord. My girlfriend also stayed also wants that.
Well,
21 okay.
Item 2.
Yes.
Item number 39 on your lordship.
39.
39. On the last day, on the directions of the court, both the parties had appeared. And where there was discussion, interaction with the court, and it was very clear that the husband is not interested. My client is also not interested.
So what you want?
Well, the parties have again been directed to appear today. They have appeared along with their son, who is in class 10.
He is here today.
They are here today.
Who will take at the first?
First part.
Because all the parties. So that they can go back to their place.
Yes. 500 kilometers away from Sundarban.
No, then we'll take it as a question. Okay? Then they will call you after pronouncing the judgment.
Item 32. On behalf of Mr.
So why you are change the pattern?
Next
Page being called.
1 second. We will phase wise. Phase one we are doing that.
Item page 2 no matter is there. Item number 30 after orders. Right, page 4, 25. 26 to 28.
Item number 10, Malas.
10
Wait.
Yes. Fresh admission matters. So please wait. It will be called immediately.
Page 5, 26 to 28. Page 6, 29 to 31. Page 7, 32.
I beg pardon, 32. Item number 32. On behalf of, yes, on behalf of Mr. Mishra, kindly taken up 2 weeks after the he has personal difficulty.
When do you want?
After 2 weeks.
After 3 weeks.
Yes.
After 3 weeks. Post after 3 weeks. At the request one. Inform your friend also.
My lord, item number 13.
30.
1313.
13. Wait.
Page 8, 33 to 37.
35 lordship.
35.
And for the appellant lordship, last lordship directed both parties to present. That from Corapota lordship due to strike lordship, they could not present.
So some other
We
date.
urgent it. You give a date to the court master, he will give you.
He will give
Yes,
it.
any date lordship.
Because and put your friend also on notice. Because he has to speak to his clients.
Yes, but I've already talked to he is there in the another court. So I've already told
All right. Which date you want?
first week of August any day lordship.
Perhaps not be. Second, third week we will put it.
Yes, lordship.
Okay.
Any date lordship.
Some date you can give appearance of.
31.
Okay.
Obliged.
21.
35.
Wait, no, not 20.
12.
Other than 20.
August 12. What? Parag?
My
Yes,
lord,
yes.
13. Item 13.
12th August. Okay. Ah.
36 to 42?
36 to 42.
43 to 43 to 46.
46.
45.
45.
45, your lordship fixed it as the first item. Subject to convenience of my learned senior friend whose matter was concerned. And my matter be taken up first. Because I have to go to Dhenkanal to attend a trial and come back.
Oh,
So 10:30 it is.
your friend is here.
No, no,
Patience,
it can be taken up
Very-
first because
Right. Next.
Mark that 10:30.
Okay. Next.
In any other matter where personal appearance directed?
Mention, but one is there. Whenever the personal matters, personal appearance is directed, in the morning you should mention so that we need not keep them waiting here. Yes.
Item 11, my lord.
11.
Yes.
Parties are present.
Yes, my
All
lord.
right, we'll take.
10 days after.
Very. See, first, okay, we'll pronounce the judgment now. Thereafter, personal appearance matters we'll take up. Bar members can be at your ease. You can go for coffee round at that time. Okay?
Item 1 for judgment.
We have taken little more time than usual because of complexity involved in the matter. Okay? We have referred to most of the judgments which you have banked upon from either side. We have given a thumbnail description of how the law has developed. Then we have gone to other aspects, and we have partly allowed the matter, and the judgment reads, in the above circumstances, this petition succeeds in part. A writ of certiorari issues quashing the impugned order of premature retirement of the petitioner. Matter is remitted back for consideration of rest, keeping open all contentions in the light of observations herein above made. Cost me deeds. We have remitted the matter to the level of committee. From committee, it goes to the full court, it goes to the governor thereafter. All right? Because of the contentions which you took, that they are stigmatic characters, I should have been given an opportunity of you. Therefore, we have said that, number one. Number two, we have not permitted your reinstatement. Specifically, we have given the reasons in the last but one paragraph. All right. This is the order. Yeah.
I respectfully agree.
You can look into the judgment also, but leave it here only thereafter. Okay.
Sir.
One Passover, your lordship.
Passover.
Passover.
Next.
Item 8.
My lord,
Yes.
item 8 can it be taken up next week, my lord? By
All up to 3 weeks at the request of. Yes. Why our
Item 9.
mic is not working?
Yes.
It's probably
Copy.
Item 9.
Item
Yes.
9, my lord.
Ah.
This is an appeal against the, my lord, questioning the legality of the order passed by the Honorable Single Judge, my lord. My lord, here the facts of the case is like this, my lord. The petitioner has purchased a piece of land under Annexure 1, the cell deed, my lord.
Cell deed dated?
This is dated 23/12/2009.
Ah.
My lord, your lordship may kindly look at the record of right.
Narrate the facts.
Yes, my lord. The property consists of two parts, my lord. One is the land recorded as Gharabadi, and the other is as road, private road. My lord, now, my lord, I was possessing the land throughout, my lord, pursuant to this sale, the purchase, my lord, and Annexure 2 also reveals that it is by personal property, my lord. Now, the municipality has acquired, my lord, illegally acquired that portion which has been recorded as a Rasta, private Rasta, my lord, and they have constructed a public road, my lord.
When it happened?
My lord, it happened on, my lord, in the year 2015, my lord.
Yes.
Without acquiring, without paying any compensation.
The definition of Rasta, a role in Municipal Act, has been taken note of by the Learned Single Judge.
No. It has not been taken note of.
Attention, prima facie, please check the Municipal Act because it defines even Baranda also.
No, as the property of municipality.
Because they will maintain it. It has a laudable objective also.
Yes, my lord. My lord, if your lordship will kindly look at, my lord.
You want compensation for that?
I want compensation for that.
No, when it was acquired, according to you.
My lord, the road was constructed in the year 2015, my lord.
2015?
Proposed to be constructed in 2015, my lord. I made several objections. I gave a grievance to the collector. Collector also forwarded the grievance, my grievance.
Your predecessor in interest of the land.
Yes.
How he sold you? He sold you because you said that he sold you it as a Rasta. Since when the revenue records show it to be a Rasta? Maybe public, private, that's one way of looking at it.
Yes, ma'am.
I mean, what was the settlement?
Annexure 2 ROR.
Date of notification of ROR. That's the question.
My lord, this is date is not exactly, my lord.
Because you cannot have a title then transferred to you by your vendor.
There is one maxim, no? Namo det quod non habet.
No.
Yes.
A person who has no better title cannot give a better title. Similarly,
yes, ma'am.
If you have got what was available, that you have to be satisfied.
My lord, this ROR, if your lordship looks at the ROR, this is in the name of my vendor, my lord.
Correct. What is the date? But you are very fair in saying that it was also recorded as Rasta.
Yes, my lord.
Gharoi Rasta, the private.
Yes, private road, my lord. This exactly the date is not visible.
Usually it is in 82.
79, my lord.
82, 83. ROR is visible.
Page 22 photo.
No, you assist him. He is searching that.
22 टा देखिए डान पर तौल रखिए जो स्टाम्प रखे.
Yes, it is 9/11/1979.
Then 22 purchase.
My lord, I purchased in the year 2009.
12/2009.
Yes, my lord.
As on that date, what was shown, how they have described that property?
My lord, that cell deed, my lord, in the cell deed.
Cell deed. In the revenue records, what they have reflected?
The same.
79.
1970.
In Karnataka, section 133, it says, the entries in the revenue record shall be presumed to be correct.
Yes, my lord.
Whether such section is there here also? Yes. Presumption of
Yes, my lord. Presumption is there, my lord.
Presumption is there.
Yes.
According to presumption, that presumption goes in your favor or against you?
In my favor. Because
it is shown as the...
Yes. In the ROR, it has been shown in the name of my vendor who has sold it to me through Annexure 1, my lord.
After you took that property in 2015, they have put up the...
They have, what they have contended in their counter in the writ application, that I had given them permission to dig and drain inside his camp, that particular area, my lord. So, my lord,
kindly repeat that sentence.
My lord, they have taken this stand. On the ground that I had given the consent, your lordship may kindly come to page 34, paragraph 4, my lord.
Consent for?
Consent for digging a drain, my lord, taking a drain over that, my lord, my lord, land, particularly that
part
is
of the public drain. I mean, in the sense, public road. So it is a common drain or it's an exclusive drain for the.
No, it is a common drain.
Common drain.
Common drain. I have given the consent for my lord,
laying the drain.
Laying that drain, my lord. Your lordship knows, my lord, that laying the drain is below the surface, my lord. Over the surface, I have got a right. Below the surface, I cannot have a right over the property, and it is for the general public, for the interest of the public. I consented for the construction of the drain.
Usually, these are open drains, not subsurface. These are open drains, surface drains.
No, but I can put a slab on that over that, and I can
over a surface drain doesn't make it subsurface. So, what is the definition in the Municipal Act of Road? That I think, sir.
That, my lord. Definition section.
The right of ownership it's the ownership is a bundle of rights. Yes. One of the rights which someone says in jurisprudence is right to use the property or right to allow others to use my property. How ownership will wither away? Ownership will wither away. Cannot be changed. By 5 traditional modes or by acquisition. Yes. Compulsory purchase, compulsory acquisition. Sale, exchange, gift. If these 3 things happen, then he will lose the ownership. Mortgage, lease, ownership still remains. It is less than a lease, less than a mortgage, because he just graciously permitted the body, local body, to make use of his land. How he will lose the ownership over the property? Number 1. Number 2, someone also discusses ownership of the land from the surface to the end coelom, to the heaven, to the bottom of the heaven. He is the owner, subject to Aircraft Act, etc., etc. All right. Now he says, I will put a slab on the drain and I will make use of the area above that. How can you object to that? He is the owner.
This is not the objection. Can I have a glance to the page 41? The operating part of the impugned order which is assailed by the
41.
Yes, ma'am.
Is it your case that you are the owner of the property?
No, we are not saying the owner.
You are only saying he allowed, he consented.
For a moment, let me clarify this. Possibly my learned friend will not dispute this. Whenever in the municipality area, the residential plot is being developed for the purpose of habitat.
Correct.
Then normally the road is being used for all. Whenever all the inhabitants
then make use
given the consent to the municipality, then and thereafter they will go through it, make the passage, make the road, all other purpose things for the purpose of the inhabitants of that locality.
Correct.
unless they will give their consent, this cannot be taken by the any municipality, NSE or anything. They cannot take up and develop the things. So far the electric pole installation is concerned.
Definition is 20. Having to, that is something alien to our case 67. 27 is private road.
Private road. It means any street, road, square, course. Passage or riding path, which is not a public road, but does not include a pathway made by the owner of the premises on his own land to secure access to or convenient use of the means any street, road, square, road, and two things of public have a right of way, whether it's a roadway or not, and includes which one? It is
the roadway once utilized over public.
See, the drains attached to any such road totally reflects for this. Kindly come to 229, which Brother Sahoo is showing. Section 3 is the dictionary clause of the Act. Odisha Municipality Act 1950.
Yes, madam.
It gives meaning of the word public road, private road, public road.
Private road has been given and public road has been given, madam.
Fine. What is not private automatically becomes public because the phraseology of that clause 29.
Yes, madam. Clause 29.
Therefore, Mohanty is saying it becomes public property. Can you read that?
Yes, I'll be reading, madam. Public road means any street, road, square, court, alley, passage or riding path over which the public have a right of way.
Whether there or not, even if it is not a thoroughfare, if it is not, even when you put some restrictions, etc., still it is a public road only. Then not only that, that is first part. There is includes definition. It is means and includes definition. See 29C.
The drains attached to any such road, public bridges or causeway and the land, whether covered or not by the pavement, so and so, it lies on either side of the road up to the boundaries of the adjacent property.
Private property or property belongs to the state. It partakes the character of public.
With that, you read 234, chapter on public.
Yes, sir.
Chapter 16, XBI. Maintenance and repair of road.
Yes, my lord. The municipality shall, at the cost of municipal fund, cause the public roads and bridges to be maintained and repaired and may from the same fund meet the cost of all improvements to same which are necessary or expedient for the public safety or convenience, madam.
So,
then if your lordship,
the statutory scheme is very clear as if you read 3, that what my lord read, 29, 27, they do it
234.
Now the difficulty what he is saying, that your vendor gave it to the municipality. You are claiming now compensation.
No, a part of it, because the entire portion I have not given.
Part of in the sense, it's a continuous road. Drain is also continuous.
It has to be.
It has to be balanced.
Or else it will go to the other definition.
So they can,
it excludes only exclusive use for you.
But they have gone beyond that drain area, my lord. They have gone beyond the drain area.
They have constructed.
Yes, my lord. They have constructed the road, my lord.
Then you file a suit for damages.
And maybe compensation.
We cannot compensation under the Land Acquisition Act. But wait.
No. Here there is a provision for compensation. 235 your lordship can clear.
235.
Yes, ma'am.
Who will adjudicate that? Read court.
No, they will provide compensation, my lord. That has been decided by the Honorable Apex Court in a case, my lord.
They drain. While constructing drain and road, they have gone to your private land. That is your allegation.
Yes, my lord. My allegation.
That.
That was sent to the municipal authority for adjudication to find out whether they have not.
That was sent
by the collector on my grievance.
So then what happened?
My lord, then they didn't do anything, my lord.
You are alleging inaction or compensation?
my lord, they have not considered my case despite my giving repeated grievances, and they have constructed the road forcibly without paying me compensation. There is a provision, my lord, 235
single judge.
D.
Now we can direct for them to consider. But was it your prayer before the single judge that they are not considering and sitting over it?
No, I have said in my writ application, my lord, in my writ application, I have specifically stated that they have not considered that. Yes, please.
If you want compensation,
Yes, please.
then there has to be acquisition. If property is taken sans without acquisition, then you should go for damages, suit for damages, or suit for restoration of the property. Because we cannot judge all that, although it's a constitutional guarantee under 300 capital A. We cannot judge the disputed facts. How much property they have taken, whether somebody had consented or not, because there is some complexity involved even in the definition, which you have read now, subsection 329 and 27 also. Read with obligation to maintain this one. See, if municipality wants, it can acquire the property. It is not your case that municipality has acquired the property. Your case is municipality trespassed your land, taken away that land,
Yes.
and they are not paying anything for that. Therefore, the protection is at the hands of civil court. We will observe that you go before the civil court. We cannot judge, and we will say whatever learned single judge has said will not come in the way. That protection will be.
But
because you have got
one case I have got the Honorable Apex Supreme Court, Malad. They have, Malad, in a similar situation, they have said, Malad,
What is the name of the parties?
Name of the party is called Kolkata Municipal Corporation and others versus Bimal Kumar Shah and others. In that case, my lord, similar situation arose, my lord, where the land was not acquired and they have, my lord, forcibly taken.
237 is acquisition. I think my lord has, after looking at that, is suggesting you. So 237, if there is a 237 acquisition, then you can claim compensation. But your case is very peculiar. You say that you purchased a land marked as noted, recorded as last, or the road from your vendor. Now you are claiming compensation from the municipality.
Yes, madam.
Now you have little bit changed your contention that while constructing, they have encroached your land or taken away some portion of it.
No, they while constructing, they have forcibly occupied my land and they have constructed the road. In their counter, they have admitted that, madam.
You have used the two words, na? Forcibly occupied the land. That is encroachment. You can go for removal of encroachment, or you can go for...
And in their counter affidavit, they have specifically said that because I have given the consent for construction of the drain, my lord, they have constructed the road. That is their stand. So they admit that they have encroached my land. So once they have admitted this being a public body, they should adhere to the provisions of the Municipal Act.
Where they have
in the counter affidavit? In the counter affidavit filed before the Honorable Single Judge, if your Lordship will kindly look at
how that consent was given, brother?
No, my lord, for the state.
You are for the state.
He is for the state. Municipality is not before your Lordship.
Then we
Yes, my lord.
will issue amended notice. Learned AGA Mr. Mohanty accepts notice for respondent number.
OP number 4.
OP number 4.
Respondent number 4.
Yeah, respondent number 2 other respondents. First, in addition to taking usual steps, appellant to serve copy of the appeal memo along with all the documents on the learned counsel who represented the opposite parties before the learned single. Let us see. Just look into, there is one decision.
Yes, madam.
Kaveri Appa versus BDA. I do not, 2021 of Karnataka Division Bench judgment. Just look into that. Kavirappa versus PDA, where to some extent it is held in your favor in identical question when BDA had taken the property of citizen. Then they said so much amount should be paid. Just look. Yeah.
That was citizen provides also 235.
For that, we should also cover. They have to acquire acquisition.
Item 10.
Seven 2025. The matter is listed today. We weren't informed. So, let's say pray and small adjournment. Any date, Honorable Question.
What substitution matters? 25. At the request of 25th.
Great.
You should come. This time is given for reading the papers. Okay.
Indeed. Late.
Item 13. Item 12.
But the merit of the case is not. Into probably at page 16, running page 16.
16.
16. Where in the Honorable Singleton, in the short order, has given the benefit to the fence sitter who came later on to the approach the Honorable Court, seeking similar benefit who acted in promptitude. They were granted the benefit, but after 5 years, some people came who never challenged the impugned order of the state.
Take notice. But the text code says once benefit is granted to a employee, it should be extended. The employee need not rush to the court. Suppose if benefit is given to one employee, the state as a model employer should extend it to rest of the employees.
That is there, my lord, but that was not observed in the earlier order. Past and then that was not in rem. And one aspect is there, the Darsem Singh case which limited the restricted limitation, fixed that earlier pay cannot be extended and it is limited to 3 years only. That ratio has been violated in this.
Emergent. It's not an idea of rem at all. The question of rem appears under section 43 of the Evidence Act. And authors like Woodruff and Amirali, they say, in 4 jurisdictions, rem orders are passed. One is probate jurisdiction, other is admiralty jurisdiction, third one is insolvency jurisdiction, fourth one is matrimonial jurisdiction. Only in these 4 jurisdictions, orders are in rem.
Persons who have acquiesced the order, how can they come subsequently? And subsequently it will continue.
No, we agree with that one. But the idea of rem is alien to the arguments.
Item 16.
My plea, your lordship. My lord, before my lordship starts, I am for the respondent.
Yes.
What has happened in this case, my lord? The assisting lawyer of me, who has appeared through the caveat.
You want time.
His name doesn't appear. That name should appear. How can I get assisted?
We just need to print the advocate on record.
Sanjit Mishra, the assisting lawyer name should be.
When do you want?
Next week, my lord?
Next week we have.
Lordship, I may be permitted. Lordship, there's a little bit of inconvenience. Lordship, on the previous date, wide order dated 36/2025, this court has directed that the present rate appeals along with other rate appeals shall come up on 23/7/2025. We have already filed the list.
Other rates are different rates.
Lordship, this is the main
This be taken up because there cannot be any confusion in between.
No confusion at all. It will come in the rest of the matter. You will have battery of lawyers who will come to your aid.
Because I will not be able to assist my lords except this case. Because it
we'll
has a
hear you.
different.
Sir, we'll hear you we'll not pass any order without hearing you that day.
Oblige minors. Minors are fixed up to
23/7, Lordship. I have given the copy of it.
All this matter on 23/7. In terms of order, it's fine, so. Okay.
Much obliged, Lordship. Lordship, interim order to continue.
Interim order to continue. Okay.
Much.
Malad, this is date appeal. Item, Malad, item.
Item 17.
Yes. 17. Where, Malad, UGC scale has been applied to the demonstrator without the state's consent, Malad. And Malad, they are saying now, the respondent, that on similar matters, they have got the benefit. So they have supplied some copies of the judgment. Let me examine the judgment, Malad.
Column 24, 25, sorry, 28. 28. Okay. That's the request of LG. Learned DG.
Item 18.
Lord, on behalf of the conducting council, I pray for an adjournment, Mr. SATAPATHY.
You have informed the other side.
My Lord, notice has not been issued. IA has been filed for condonation of delay, Your Lordship.
How many days delay?
10 days of delay, Your Lordship.
We'll condone the delay. 10 days, na?
Yes, Your Lordship.
Who appears for the, any notice has been issued already?
No, Your Lordship, notice has not been issued. It has come for orders, Your Lordship.
Issue notice. But who should, who appears, any standing counsel?
My Lord, there are many, there are different councils, Your
Issue
Lordship.
emergent notice, returnable within 2 weeks. Post immediately after survey. Yes.
You are taking notice to all four.
Yes, Your Lordship.
It is to be furnished within 3 working days, 4 working days.
Obligation.
Item 19.
It's that new rule matter, Malad, when rehabilitation assistance new rule, amendment rule.
Covered by judgment.
Covered by the judgment.
Yesterday also you have done.
Judgment already published.
Yesterday we have done that.
He is also passing on that judgment, Malad, in hardcore.
The subject matter of this Supreme Court, our judgment.
Your Lordship's judgment is also there. Your Lordship's judgment. I will pass on the judgment to the court master.
Same.
Yes, same judgment.
Identical law.
In fact, so before the Supreme Court judgment came, Your Lordship has already formulated that principle. Supreme Court.
That's this court.
Writ appeal is also filed.
Also keep the Supreme Court judgment in file. Mr. Behra. Supreme Court judgment is filed.
Yes.
Due to delay, my Lord, that was filed, my Lord. So, Your Lordship.
Condonation of delay. How many days?
My Lord, 184 days.
Delay application, standard format.
I am for the respondent. All the matters, my Lord, sir.
How many?
Yes. Item 19 matters.
All matters.
Yes.
All matters are similar. 5 matters with that.
Yes. Yes.
Item 20.
Delay of 18 days, my Lord. Delay of 18 days. In filing 18 days.
What is there on merits?
Merits, merits, my Lord. The kindly say, the 5-6 persons, they were selected as CRCC as custodial resort at primary school teachers.
In the full form. And not at your speed.
Cluster resource
Center coordinator.
But 2013, there was a fresh election. We are not intimidated, and the relief order issued by the BDO and never communicated to us. So all 6 persons.
Sir, which was the impugned order before the learned single judge?
Single judge
Prayer.
Prayer was that to grant salary the period where discharge duty.
Your discharge duty?
That was allowed by the honorable single judge.
One second. You discharge duty as what?
As a primary school teacher. Original, my Lord.
Teacher.
My Lord. CRCC is a part-time case.
One second.
My Lord.
School teacher, part-time teacher.
No, we are regular teacher.
You are regular teacher.
Teachers.
From which date to which date?
From 1/3/2015, sorry, 1/6/2013 to 28/2015.
1 for 2013.
No, 1/6.
That is the impugned order.
Our prayer was
Month March.
yes, 1/7/23 to 13 to 28 to 15.
That is his prayer.
Prayer.
Prayer Roman 3.
Yes.
Yes.
As duty.
Duty.
So how it was treated?
That are
Not
treated-
on duty.
That are treated by the coordinate bench as a duty, release this, the direction release to release the salary.
No, sir, the authority, how it treated?
They say no work, no pay.
But no work.
No work, no pay.
No pay.
No pay.
They have worked for that.
You are what? And going to the bench.
Slowly, one by one.
Yes.
One by one. Halt and proceed.
Madam.
You will see the board on the National Highway. Halt and proceed in Bhubaneswar, etc. Halt and proceed. So 1/7/2013
Madam.
to 28 to 2015,
Madam.
you have worked as teachers.
As a teacher in the school.
Is it?
No Millers.
They have not.
After Miller's 16/4/2013, he was relieved from the CRCC and brought back to the original post Millers. Thereafter, he has not worked in the school Millers. What he was
After he stopped going. They stopped going to the school, but he's a government employee.
government employee, not work in the not go to the going to the school and not work for that period Millers.
Why?
They're
Why
not
he
in
did not-
Millers after relief CRCC Millers cluster
They
center
had some
coordinated.
clusters for training for the teachers, where these teachers
Yeah,
will prefer
Yes,
there.
May
So
I,
I mean, Mr. Mahanti, it is like, I mean, both of you, Mr. Mahanti,
yes,
younger Mahanti.
Millers.
So where he worked, did he give any attendance or any, like
That is
one
that is
office?
attendance sheet in the office Millers.
Yes.
Yes, I have categorical rejection order. Your Lordship, see page 40 of the brief.
Of the writ appeal or writ petition?
Read appeal.
may
Annex 6.
0.
Start from 39.
may
Mr. Mahanti, we are not, yes, you were trying to grapple with the facts.
Facts we want to. That's
Lordship, see that Miller's operating person. My rejection order is that. Last paragraph, last but one paragraph. In view of the observation made by Honorable High Court of Orissa in the above quoted order, the record from the office of the headmaster of the school was verified. It is verified that petitioner has not worked in the present school since the date of his relief from CRCC on dated 16/4/13 till his joining the school on dated 27/2/2015.
whether teachers are bound to mark the attendance.
Yes.
They are bound to mark the
Yes.
attendance.
Record has been maintained.
You show that the school record, you get the attendance register.
That's-
And during that period, no classes are taken.
No,
that is
No classes
exactly.
are
no,
taken.
no classes taken.
That is exactly.
Lordship's impugned order, your Lordship, see that paragraph 7.
In my lord,
Paragraph 7, page 46.
You produce that register,
May-
attendance register.
may I pray one thing? I am petitioner. Kindly see Annex 1, page 25. 6 persons relieved. 1 person approached, all approached my lord. My lord decided in one case that they are discharging duty, give him the benefits, salary. That is complained by the authorities. That is my entire case.
No,
Once,
problem is you did not report for duty.
kindly see my lord.
After 16/4/2013.
Kindly see Annex 1, page 25. Kindly see. One minute, madam. Kindly see Annex 1, page 25. These 6 persons were CRCC. They all relieved as per their version.
Yes, all they relieved and
They are discharged duty as a private school teacher. Relieved from the CRCC.
Mr. Mahanti, did you challenge that High Court order which directed for verification of the
records.
No, that because
That unless you challenge that, that is binding on them on.
No, kindly see, madam. Similar matter came before my lord single bench on page 34. Honorable single bench, single judge decided in favor of one Rabindranath Pandit, serial number 1, that they are discharged duty.
Mr. Mahanti, you kindly appreciate what is being told to you.
Madam.
Rabindranath Panda, whether he worked or not, that the other it could not have decided. Single judge in his wisdom, I mean, correctly also,
Directed
that
verification of
verify and
records.
give.
Yes.
Now when they verify and do not find your attendance,
Yes. They say
they are bound by that order.
No.
That's the difficulty for you.
But my submission is
No.
not single judge.
Now to assert,
Huh.
bring the attendance register for the said period. Do you maintain attendance register? How long they are kept actually, Mr. Monty?
My lord,
All the time you are kept.
It is
Nowadays it became how many percent?
It will be available.
I'll get better.
Very simple. Nobody can say I have attended,
Now it is a
etc.
Biometrics is
What is biometric records?
If it is there or the physical
if
records.
available biometric record or register, I will provide.
The short
Anything
question is
available.
as to whether
Biometric after
appellant-
6 months, it will be.
the appellant had worked during the period between 16/4/2013 and 16/4/2013 and 28/2/2015. First off, this question arises because of salary implication, wages implications for the said period. First off, learned counsel for the appellant teacher asserts that he had worked, and learned state counsel denies this. First off, this short answer to this short question can be ascertained just by looking into the attendance register for the said period. First, next one, in view of the above, the respondent, which respondent?
Respondent on 5 minute view. 5.
The respondent is directed to produce the attendance register concerning the said period as it relates to petitioner, appellant, on the next date of hearing. First, non-production may result into an adverse inference being drawn. Yes. Only then orders are implemented.
Lordship,
If we just leave the order, nobody will.
Sir, I have answered that order will be implemented.
In our order, we have to put one cobra. That if you do not do it, will bite that way.
I'll ensure Miller, sir, if have a look there.
Yeah.
Except that matter. In that matter.
Doing some.
In that matter.
29.
29.
29? All right.
My lord.
Item 21. My lord,
Yes.
my lord, I am BC, my concern CG is in the court. Here is the case, the union is prepared to file an appeal against the order of the Honorable Single Judge, my lord. But there is a 60 days delay. Lordship may issue notice to other side, then a delay may be power.
Jena is
Only
appearing.
60 days delay.
You can mark in the VC, Mr. DSGI. Mr. Jena is appearing.
My lord, today I'm filing.
Yes. Then I'll serve the copy or in presence, Lordship may condone the delay.
No. Give him a chance.
You have to fill your
Then I'll Lordship.
Let a copy be served.
Yes, we'll serve the copy.
But then, since he has already appeared, we accept.
See, look, so appears for respondents. Which are all respondents?
Yes, my lord.
All respondents. And seeks a short accommodation. First off, for this matter on 29/7. 29/7, all right.
Yes,
ma'am. Yes.
Copies of the appeal memo it be served on Mr. Jena appearing for the was it supposed to appear? He has filed local account will be taken. He appears, we said. That also should be stated.
He has also paid power.
Mr. Panda will serve the copy. Yes. Item 22.
But item, I have collected the correct address.
The employee is seeking review of the order, my lord, under Minimum Wages Act.
Our order.
My lord. Well,
Ordered by us or other bench?
by other bench where my
What
justice
brother was there?
that the review is mainly filed, my lord. What happened while disposing the matter, this honorable court directed the commissioner to give the records. From the records, we found a document which shows that the bank has the authority over the employee. Here the finding was that since the bank he has employed under the contractor, not under the bank, so bank has no authority over him, and therefore the state government is the appropriate government.
For the purpose of reference under 10?
Minimum Wages Act, my lord.
Minimum Wages Act.
Your my lord, they have paid central government, she claims central government wages, minimum wages under central government, but under the state government, kindly have this document.
Never that purpose. Most immediate.
Both on IA as well as the petition, take notice.
Man. That document, my
It
lord,
is.
document.
No, let them come. Because that will not help you in maintaining a review because it is subsequent.
But I discover it after the
So that judgment. After the judgment, so
since this court directed.
So let them appear.
Right.
3 days. Requisites by speed post.
Right.
Requisites by speed post for issuance of notice within 3 days, 3 working days.
Item 25.
Declaration of a junior typist under the family judge cut-off matter. Admittedly, there was a creation of post by the government under the family judge cut-off. Lordship kindly down to annexation 1.
Post was created.
Bigger pardon?
Post was created.
Post was created.
When it was created.
And I'm reading out, madam. And directed to convey the sanction of governor to creation of the following gazetted, non-gazetted post.
What is the date? Which page you are referring? What is the date?
Page 9 should go.
Date.
Which year?
17/5/2010.
Page 9 annexure 1, madam.
17/5/2010.
17/5/2010.
17/5/2010, madam. Page 9 annexure 1. I am directed to convey the sanction of governor for the creation.
We go further. We believe you. We don't doubt the lawyers at all.
What I am trying to convince before Lordship is, Court Bhubaneswar in the district court, that is a family court. The post was created for family court. Yes, ma'am. That I am trying to convince. Lordship can look at
It says family court.
Serial number 7.
It says family court Bhubaneswar.
Bhubaneswar, no, my lord. Family court, Bhubaneswar. Yes, madam. Yes, I'm sorry, madam. My apology. Bhubaneswar. Serial number 7 is the typist.
Yes.
Then your lordship kindly turn to the page 11, dated 27 April 2012.
You narrate. If we doubt you, we will ask you to turn the pages.
Yes, my lord. Lordship,
we doubt you, nor you doubt us.
No, my clarification purposes, I said that because my lord asked the previous day, therefore I'm saying.
Yes.
Page
Then
11, advertisement was published by the family judge. Lordship, look at the bottom. Page 11, annexure 2. Advertisement was published by the judge family court.
Dated?
Dated 27th day of April 2012. Well, I participated in the advertisement along with 150%. Then I was appointed, Lordship kindly 3, annexure 3, page 13.
Appointed?
The person to the government law department such and such, the following persons are appointed. Page 13, annex 2, dated 21st May 2012. Annexure 3, page 13. By the family judge cut up. I'm sorry, madam. My name is serial number 2. As typist, I was appointed after contesting along with many persons, madam. Then your lordship kindly turn to.
Yes.
Then, my lord, the memoration was granted. It was extended from time to time. Then after, there is a provision in rule in page 17, dated 12 November 2013, because all appointments in the state of Orissa were, so far class 3 and class 4 posts, were contractual basis. There was no regular recruitment. And it was stipulated yes, madam, in all throughout the state.
Converted to be contractual. After 6 years,
yes, madam, C and D.
Withdrawn. That has been withdrawn. But that has been withdrawn?
Withdrawn. And 12 says, my lord, that after completion of satisfactory service, they will be brought to the regularized or regularized. That you will also get from page 12, 21.
Single matter. 6 years after completion of 6 years. We treated it.
Page 21.
Maybe contractual.
Page 21, that is 6 years after they will be regularized. Column 10, Roman 1.
Yes, sir.
So the rejection order which is challenged here, that is annexure?
That is annexure, my lord. Annexure 5.
5.
No, and that is annexure.
So it is not supported, it is only 3-line letter, no reasons have been given.
No reason, that the very difficulty is, annexure 9. I'm sorry, madam. The very difficult is there is a dispute between district judge and family judge. There is no other dispute. Now the district judge says, I am the appointing authority. Therefore, the family judge has no jurisdiction to appoint. The only dispute.
Your representation is at 25, page 25.
As page
25 is the representation, 26 is the rejection.
25 is my representation and 26 is the rejection. Okay.
You are agreed by 26.
26, page 26. There is no dispute relating my appointment or selection, anything. I'll bring your lordship's attention to page 22. I'll bring to lordship's attention page 22, madam.
So, Mr. Lordship is asking the Learned AG.
Oh, right.
District judge has been pleased to reject the representation dated so and so. He is not President of India. He has to give reasons. Only President will not be required to give the reasons for rejecting the mercy petition.
Your Lordship, see annex of I think 9.
Where is the reason?
Reason I have given by the civil court register. Lordship, see that counter filed by state that page Millard's.
How reason can supplement?
No, reason as prior to that. He is referring that order dated 18/5/19.
18/5/19
Millards. In rejection annexure 7.
I'm unable to get that. 18/5 is not mentioned. Where you are referring?
Annexure 9, page 26. It writes as if he is President of India.
Prior to that, Millards, your Lordship, see that Millards. Prior to that, rejection has been made by the registered civil court, Khurda at Bhubaneswar, Lordship.
But he is not the authority. That is again a problem.
Authority is appointing authority.
Authority means appointing authority. No, register communicated the reasons given by the district judge. That is your case.
Here is a case, Millards. Post is created by the government finance department. It's a permanent in nature. There is no contractual Lordship.
Post is created permanently.
Permanent nature.
Correct. But appointment is made on contract basis.
That as per the rule 2008 of the appointment of non-judicial staff, the family judge have no power to make an advertisement, Millards, for contractual basis.
How many persons he appointed?
One person, this person without any written exemption.
Only one person is appointed?
Yes.
Serial number 1 and 2, there are 2 persons. If you, when Mr. Misra was referring to that.
Subject matter of the case is one.
Subject matter always. But in respect of others, what did you do? You cannot be selective.
Millards in 2019 by order of this Honorable Court, Millards family court is kept in abeyance, Millards, and his job also is kept in abeyance from the Millards 2019 Millards. He has not worked more, my lord. Now he is not working.
No, this was, now it is not working because you installed it. Now see, advertisement is dated.
Advertisement, as per the rule, family judge has no power to make an advertisement.
After how many years you will say that? Suppose Alexander had no power to come here, but he came and went back, although died on the way. After how many years you will be able to say, no, your appointment, you can't say what adamant you did wrong and they had no jurisdiction to enter the Eden Garden. How? After how many years you are asking this?
Let's see.
One second. We'll give you the factuals now.
Yes.
17/5/2010, yes. The post is created. Posts are created.
Yes.
Advertisement is 7/4/2012.
Yes, ma'am. By the family court.
By the family court. They have drawn the salary.
No, salary not drawn from the district fund, Millers, district judge fund, Millers. It's a Millers salary drawn from the family judge, Millers.
Correct. Family judge.
Family judge
means is he giving from his salary? He gives it from the fund only.
Fund. I think
so. It's a public fund only. So that is created because of allocation from the state.
Yes.
Correct. And he sought for regularization. By his application dated 16/5/2018. You have rejected.
Yes.
Have you removed him also?
Yes. Not removed. That vote is kept in abeyance, Millers, still done, Millers.
No, you don't understand that.
No. Not removed, Millers. That family court itself kept in abeyance until further orders. Thereafter, his post also kept in abeyance until further orders.
How can that be?
That is Millers. That is on record, Millers. I will show that record.
You are not denying that there is an advertisement and a selection process.
Yes.
What happened to that? After the advertisement applications are invited, there is a selection process, everything happens.
Appointment order is issued on 21/5/2012. He works as typist.
Advertisement issued. Millers, advertisement was issued. But Millers,
contractual. All contractuals, they do it for 1 year only.
1 year, thereafter extension in this
that case. Their problem arises.
There was the extension by the family judge.
How long?
How many years? The rules.
How many years?
From 2013 to 19.
12 to 19. 12 to 19. 5 years. After completion of 5 years, he seeks a regularization. How many years? You are under your GO, there is some resolution.
That is 5-year contractual service, Millers.
5 years.
That is, his appointment is prior to the contractual rules 2013, Millers. He came into force in 2013, Millers.
Correct.
My contention is that rule is not applicable to him.
Why? It is pre-rule of appointment.
There is no rule, Millers.
That's what. Therefore, I am telling you.
There is no rule.
Appointment is pre-rule regime. There was no rule at all.
No, for contractual appointment.
Correct.
Yes.
Therefore, whether your new rules say all other appointments which are being done till this day should go away.
Oh, that is silent about.
Then silent means they are very consciously they are silent.
Silent about.
Means they should continue. Otherwise, where is the question of? Otherwise, what happens is, I will tell you.
Yes.
All those who are appointed on contractual basis after the rules are promulgated, they will be working for a shorter period than those who are appointed earlier to the rules. You will deny benefit to the long service people, give benefit of regularization to the short service people. That will be arbitrary.
That is Miller's settled law. I do not dispute Miller. Lordship, see that my counter Miller 6.2.
6.2.
Yes.
Now, anyway, where is the reason assigned by the judge, district judge?
Miller's reason assigned Miller's at annexer 3/2. Miller's state filed, Tamil judge filed counter affidavit Miller's that Tamil judge Bhubaneswar.
3/2, page 57.
3 by B.
Sorry?
Page 11.
Page 11.
Yes. Counter affidavit filed by the copy number 3.
3. By A3.
3 by B series.
Page 79 of Lordship brief. 79.
That is, and page is 11.
Running page, that would be 79.
73. Oblige. Representation.
The same representation is referring.
Yes,
But this is not under challenge.
not challenge. In reply to a representation provided by the Judge Family Court, Bhubaneswar, by his office letter as such and such, I am directed to intimate that after receipt of the representation dated 16/5/18, provided by Judge Family Court, Bhubaneswar, by his office letter number such and such, paying for regularization of your service with effect from 1/6/2018, a commit
Can you
was...
read slowly? After rejection, post rejection, another again reconsider.
Yes, my lords. That is the language, my lords. His office letter number such and such, dated 16/5/18, paying for regularization of our service with effect from 1/6/2018, a committee was constituted for considering your representation. The Learned Committee, by their minutes dated 10/10/18, has opened that further, the Judge Family Court, Bhubaneswar, is not a competent authority to make any regular or
One second.
contractual appointment.
Mr. Mohanty,
My lord.
that committee was constituted under which rules?
My lords, under rule Odisha District and Subordinate Court non-judicial staff method of recruitment and condition of service, my lord.
Of which
That-
year?
2008.
2008.
Yes, my lords. Section 6, my lords.
Because when you say it's not competent, you do not refer to the rule also.
But rejection is also by him only. Rejection is also by him only.
That is non-speaking rejection, my lords. I admit that because there is no reason has been given in the...
Not only no reason given, the person who is according to you incompetent to make appointment
Yes.
has considered the application for regularization.
No, my lords, he has considered the application, no written exemption. I have taken in the counter, stand in the counter, no written exemptions. Only basis of Iowa test he has appointed as that person for the...
Because at that time there were no rules.
Yes. 2008 rule.
Who is the appointing authority?
That is committee, my lords.
Where is which rule?
My lords, that is section 6.
Just give us a moment.
Section 6, my lords.
Just that's the last one, sir. Near
Lordship, volume 4 local laws, my lords. There is volume 4 local laws. Yes, my lords.
You are referring to which rule?
Lords, that is Odisha District and Subordinate Court non-judicial staff service method of recruitment and condition of service rule. 2008. This is a local law manual, my lords, volume 4. Volume 4, page 453.
Just give us. Get the fourth volume, kindly do.
Page number, Mr. Mohanty?
Page, my lords, rule 6 is page 55, but rule is, my lords, start from 453.
455.
453. Relevant rule is, my lords, 455. Lords, section 6.
Who is the appointing authority?
Lord, there is a committee, my lords. Recruitment of the post of junior clerk, typist and copyist in the district court and subordinate courts of each district shall be made by the competitive exemption to be held once in the year. Recruitment to the post of stenographer 2, junior stenographer shall be made by the competitive exemption where
Where is the reference to committee?
Subsection 2. There shall be a district recruitment committee for each district consisting of principal district judge and session judge.
Some witness. So it is in violation. Initial appointment itself is bad.
Violation, my lords. And so far rule 4 is concerned, my lords, there is referring the recruitment subject to other provision made by these rules.
That you have not said.
Yes, I put that in impugned order, that is silent, my lords. I admit that. That is not stated.
No, this you have communicated to the particular person, 18/5/19.
Yes. Yes.
But that communication, does it refer to this or this is subsequent to that?
That's communication, my lords.
Rejection is 24/4/19.
Yes.
You are relying on that annexure.
Annexure 3 by B series, lordship 18/5/19. Lords, I have referred to that rule, my lords. 2008 rule in a rejection order also.
So very entry itself is without authority.
Yes, my lords.
Yeah, that's communicated also.
That is
Nothing
communicated.
can be done. Yes, brother, your entry, the epicenter itself is defective.
Let me complete, madam.
Yes, sir.
That rule has no application after the family judge court was declared a directorate. That will also kindly turn to page 21, annexure 7.
No, that rule has exception.
Nothing may kindly show. In our state hierarchies, state cadre, director cadre, and district cadre. Once a district judge is divided in two director, the district judge has no role to play because the family judge is declared as a directorate. Nothing kindly turn to page 22, read with annexure agenda, page 7. Therefore, that rule has no application because that is related to appointment under the district judge. When family judge is declared a directorate, it is a different.
There is no provision for the power.
No, it was declared a directorate. So nothing can look. I am direct to say that after careful government have been pleased to declare the judge, family court, Bhubaneswar and Kota as the head of the office.
So, Mr. Give us a moment. Mr. Just give us a moment.
Therefore, that rule has no application.
No reference to family court in there. Because family court is below the district judge, principal district judge.
But, Millard, as per the notification, High Court, Honorable High Court, Millard, even if below the district judge now, Millard, prior to that, Millard's family court is Millard's as per the notification of Honorable High Court, even if additional judge could be appointed as a family judge,
but not no.
Additional district judge may be appointed. Administrative power vested with the district judge.
Mr. Mishra.
Yes, madam.
There is no such bifurcation under our rules.
Madam, Dr. Kindly also see regender to page 7 to the regender of regender to the reply to the opposite part of 3 months. My humble submission is once the government is empowered to declare a particular authority as a director, that is 3 hierarchy. In state cadre, one is a director cadre, another district cadre. One district cadre can be bifurcated and state has done it and declared the family court as a separate directorate. That will okay see page 7 of my region to the counterfeit filed by the opposite part of 3. Page 7. It is under the statute they have done it.
Millers, I have clarified that position in state counter affidavit, Millers, at para 6, Millers.
Forget about the counter. Look at the government order.
I have clarified that.
Counter by OP2.
Countered by OP number 1, state counter.
OP number 1.
Yes, Millers.
You have any reference?
That is clarified.
Additional affidavit. Page 84, sir. Page 84 of the lordship. Yes, it is gone below actually. Maybe did get a file.
Counter. 84.
Which paragraph you mentioned, Mr. Monty?
Let's that is para Millard state counter of the para 6 lordships the page 4 state web internal page state 4.
6 is 3. Page internal running page 86. That in reply to the governments, within 3 and 3D.
Yes. 3A to 3D.
is a kind of office, but it's not important. So, the voice of the mention rules. Produce the water. Office for smooth functioning of the financial power only for self-based tax and not for the court. But
So 4 and 5 has to be made.
yes,
And 4 and 5 has for 4 and 5.
correct. So the question about the appointed.
The same doesn't ipso facto vests authority just to issue advertisement.
So, this is
Mr. Mishra, what we have been discussing, is there any rule governing the field? Because
No,
2008 rule, we have checked, there is no exception.
No, I said that rule has no application in terms of page 24.
Correct. You suppose we are well aware of your submission. Once you said that the 2008 rule is not applicable, suppose we are accepting that, then which rule?
Family judge is a separate cadre. Family judge is separate cadre.
So that
And
is
director is family judge. By
so
virtue
separate
by-
cadre, yes, that is a very serious submission that we have to declare that family judge has his own cadre. It doesn't belong to that Odisha minister, district judges, district court, subordinate court, judicial, whatever that long.
Yes,
title.
because one director is changed.
Declaration Odisha district and subordinate courts, ministerial service, method
Has
of
no application.
rule 2008 is not applicable because the cadre is defined there. Kindly look at that rule. Cadre defines the cadre.
Yes, ma'am.
It doesn't exclude anything.
No. But
All pervasive.
my humble submission is that was in 2008, but the cadre was created in 2008.
And the sinking boat, as you have relied on that OGFR,
Yes.
declaring a directorate of
Yes.
itself is a directorate.
Yes.
The purpose is different.
it's a
So
direct.
then we have to also say that general financial rule will prevail over the recruitment rules.
No, not only that. If we agree with his contention, we will be compromising High Court's control over those employees.
employees also.
That cannot be.
In 2013, referred that.
Some of that I will physically appear and contribute to the-
You do not bother about
Yes,
it.
and they have taken permission from High Court also.
Provision of relevant rules.
Permission of?
High Court has so intimated that I will give, let me keep it, some of that I will go physically and convince your lordship.
No, we have heard you. We will not hear that heard reserved.
All right, ma'am.
Any citations, anything, you can give the list.
My alternative argument is, I was duly, I am not aware who is the appointing authority, what is the process. I was duly selected, appointed, completed 6 years. Therefore, I am entitled for regulation otherwise, because I have not violated Article 14 and 16. My appointment is consistent to Article 14 and 16.
All right. Heard reserved.
I'll find a note, madam. Does it permit to file a note, madam?
No, we have reserved whatever you want to file. We have reserved it. Give it within 1 day, we may look it. Otherwise, 1 day we will have an order in article. This side or that side.
All right. Obliged.
No content file. Yes. We have heard that.
matters for fresh hearing, my lord. Notice.
Come back at 2. Because we have already.
You want time in that matter?
No. Notice is required to go other side for hearing.
Similar matters we have already issued notices.
It's a intercession between police personnel, my lords. That is
Item 29.
29, my lords.
Neither 18 nor non-delivered notice returned from R1.
Let's.
We have to wait.
My lord.
You yourself check or,
Wait, no.
Let's.
or if you want, you can take fresh notice.
No, my lord.
But you check and then you take fresh notice.
Yes.
I may permitted to mention, my lord, item number 19, which was disposed by your lordship today, my lord. My lord, at the time of filing of disposal of WPC, my lord, Superintendent of Police as opposite of core and disposed of, my lord, as additional Superintendent of Police, but that was subsequently amended by this London single bench, my lord. But here, at the time of filing of writ of appeal, my lord, government has filed this writ of appeal.
Posted it to some other date.
Pardon? Item 19.
19, but will it, have you seen our order?
Yes, ma'am.
We do not refer to any authority.
Yes, but they have made this.
Avanti, can you provide him a copy of that? You want amendment of cost title?
Yes, ma'am. That cost title which was made, my lord, additional Superintendent of Police, Puri, Outpost PS District Court of mention is. So that it may be clarified by your lordship's own order, my lord, that may be clarified. Superintendent of Police, Puri.
Write it in a piece of paper.
Yes,
and the writ number also.
Yes,
there are 4 matters.
First 3 items, my lord.
So please write it in a paper.
Yes, ma'am. Oblige.
And show it to your colleague.
Oblige.
So both of you sign and then.
Oblige.
Without disturbing, I'm sorry.
Yes,
Lord, one item number. I'm sorry, Lord. If I'm not disturbing my lordship.
No problem. No, actually, we are continuing through one matter. Actually, that
family matter.
Family matter that spilled over after recess since we interacted. So after that, you can mention. Mr. Mukherjee's matter. That is item.
Item 39.
Say, writ appeal, my lord.
Yes.
The order passed by.
Yes, your matter.
I'm sorry.
It has reached.
Yes, this is the same matter.
Same matter. You were saying something.
No, only about this 7.
Pardon, my lord. I am appearing for opposite party number 2, my lord. Director for special project, my lord, MGNRGS, my lord. I have specially engaged in this matter, my lord. Special counsel, Narega.
You want copy of the petition?
No, my lord. One copy maybe. Opposite party number 2, my lord.
7.
Item number 7.
Director is the appellate authority. It's a disengagement order passed by the collector. We preferred an appeal before the director. Appeal is dismissed. We went to challenging the order we were before the Honorable Single Judge. Honorable Single Judge has dismissed the matter. They are a statutory authority. So they can defend the order. They have, for subject to lordship.
No, I mean, so the learned senior is saying that as far as merits are concerned, you may not have any say, but you have your copy for professional purposes also.
How many years he has served?
But he has served from 2008 to 2021. Almost 13 years. And the ground of disengagement is poor performance.
Poor performance.
Poor performance. And he is a contractual employee. Not so-cause notice was given. He has explained it. His so-cause was not dealt with. Equally, before the Honorable Single Judge, if lordship sees, the disengagement order says that I have achieved 8% of the target, whereas there are people working who have achieved 3% to 6%. I am giving
on what parameters you adjudged the performance? You can say poor performance. Poor is a very elastic word.
Project and comprehensive guidelines for the Gram Rozgar Sevak under the NGROE.
Madam, sister wanted to engage some advocate.
No, she herself is appearing. One of the parties
is appearing for option number 2 as a special counsel for Narega.
The counsel is saying that she doesn't have to answer anything. That's how we can proceed.
What is the normative basis to assess the performance? What are the norms?
There is a comprehensive guideline for the selection and engagement of the Gram Rozgar Sevak. That is not annexed. I can provide it also.
May I interrupt you? Because the issue is that there is a competition for non-performance.
Yes.
So the best is 8, below list is 3. So that is how. So in that case, that scenario, how you find that 8 is bad and 3 is good.
Because there is a target within a period of 1 year. How many houses has to be completed? If the target is 168. Out of 168, so far the present petition is...
We are asking one question to you. Have you retained any black sheep which has performed less than what he has done?
No, ma'am.
Where have you stated? Where is your contention?
Just see page 32.
32?
Page 32. I have given a chart of the performance.
Page 32.
Yes. And also before the Honorable Single Judge, that was my ground. Page 32, lordship may kindly see. I have given a chart of these performances. My name finds place at serial number 11.
Pana.
Yes. 8.93%. Lordship will get that, my lord.
Correct.
Then just intervening one, your lordship will find 6.32. C is retained. Then below that, your lordship will find 6.96. That is 6.96 at serial number 21. I'm sorry.
Sahaspura.
20. I'm sorry. 20. Baripada. 6.96. Then towards bottom, lordship will find third 3.33. From bottom, 3.33.
That could be 8 point or 3 point.
This is 3 point. Maybe as it appears to me, it is
to be 3. 8.20, 8.15.
But correct.
What was their explanation in the objection statement?
Well, objection statement has not been given. This is a writ appeal.
In the writ petition,
what was your
given the objection?
What was that?
So for the counter is concerned, Miller, the other persons, those who are less, so far this achievement is concerned, they have been given notice and they have upgraded their performance.
When notice was given to the appellate?
6/11/2020, 9/11, 6/10/12.
6/11/2020.
2020, Miller.
And 9/11 again in 3 days.
Yes,
within 3 days, Rome will be built.
Miller, this has been given so far this writ appeal is concerned, that has also been annexed.
No, when you asked him to improve, did you point out the deficiency? Or just saying, improve yourself? What improve? What are the deficiencies he pointed out? Where is that notice? He should be in a position to understand your notice, no?
I'll file a detailed shows, keeping in view the tabular form. So for the other parties,
It should be very objective. It cannot be subjective. Objectivity. Now he is saying, those who are far less than me are retained in the service. I am being victimized. And appears to be so. Appears to be so based upon the statistical data available on record. You can't be that discriminatory. You should tell.
That should not be also. I'll give the details because it is for a 1 year and very meager salary. I'm conscious, Milan.
No, not only that, according to you, Rome is to be built in a day.
No, is it possible?
And the other part is that within 7 days he will improve.
And that is 10.
So, according to you, have you ever contemplated what is to be done within 7 days?
Not even 3 days.
Not even 7 days, 3 days. Yes, Mr.
3 days.
3 days.
Kindly see page 75.
Within 3 days, a miracle should happen. How?
9/11 notice, improve by 12/11. I'm sorry, Lord, I disrupted.
Yes, yeah, they have given that notice. We have allowed another matter in which Mr. Panda appeared. Within 3 days, nothing can be achieved. We have allowed that matter. We granted relief to the citizen. Next court said, Justice A.S. Venkatramayya, a great judge of the Supreme Court, said, when you are asking an employee that your performance is not well, you should tell him what are the pitfalls. If possible, the measures which he should adopt to fill the pitfalls. You can't just say, no, your performance is not well. Suppose if we say to our employees, your performance is not well, how are you going to a judge? They will laugh at us.
I will specify this.
Because the problem is Mahendra Singhil or Gunapani Dey, whatever you say, page 12, Annex 2 in the writ petition. It says your performance is very poor against your total allotted target, 168 out of which till date you have completed 13 houses, which is 8%. So what do you mean by that?
3% are retained. 3%, 3.2% are retained.
Suppose you say that you have not done this. The house you have not built. Is it that he's an engineer or a builder, he will construct houses?
No.
I think construction activities by the persons who are the beneficiaries.
Complex activity. So many things are
only
involved.
look after the things and process.
But you are attributing completion to him.
Just look into it, give us.
I'll have a discussion and file the details affidavit.
But that is in the appellate stage.
But at least let him permit him. Learned senior advocate, Mr. Atho, appearing for the appellant, points out that his client has been victimized apparently. And in support of that, he draws our attention to the case papers, which prima facie reflect that poorer performers have been retained as against comparatively better performance of the petitioner, appellant. First, learned AGA, Mr. Mohanty, seeks some time to counter this by placing some records. First, leave to produce rebuttal records is permitted, and he shall do it after serving copies of the records on the other side. Call in the first week of September, August 20. First week we have difficulty, Mr. Atho. We'll have it in the third week of August 2025.
My appearance may be noted.
Yes,
One copy may be served. If request, I will file my response also.
Your response in appeal.
So where are you providing a copy?
You have not filed your response in the writ petition.
No, my lord.
Now you want to file.
My learned friend will appreciate appellate authority did not file a response. No, they are
She appears for the appellate authority.
Yes.
Yes.
What is that? You have to justify, I should fall or
Yes.
stand or fall. Yes. Next. Grateful. But appellate authorities are not to be made parties, said the apex court. Latest judgment.
Since it is that
Administrative order is order there. Anyway. In fact, the difference between
nine, sorry.
Item 29.
29.
29 years, matter relating to the fixation of inter-se seniority between the police personnel, operation and mechanical. Lordship, the RW was dismissed on the ground of delay. The state went to the Supreme Court and Supreme Court condemned the delay. And thereafter, Lordship issued notice on the 3/5/2023. But so far as respondent number 1 written on deliver.
take fresh steps.
Yes. But the others are sufficient, received the notice but not appeared.
It's all right. For in respect of unserved people, take fresh steps to be taken immediately in respect of unserved respondents. Post after service.
Yes, on it, let's copy maybe utilize.
You are looking at the office note, which says all are served.
That is
X1, X2, X3 flags.
All are served.
All are served.
Item
delivered to all.
No, neither add-in or undelivered notice written from the R1.
R1. But can you look at X1?
Yes. X2 and X3.
Correct.
They are served.
Tulsipur, item delivered Tulsipur. Then X2 is item delivered Aerodrome area Bhubaneswar. X3 item delivered Puri at the office.
Yes, delivered, no?
Yes.
We'll call this in the first week of September.
Yes.
The postal track record.
Yes, track consignment India Post.
Shows service on all the respondents. First term. However, they are not represented before us. First term. In view of that, the appellant is directed to serve a copy of the petitions, appeal memo, along with all the documents on the learned advocates who represented the private respondents before the court, before the learned single judge.
Before Supreme Court remand, they were heard. They are aware of the Supreme Court order.
No, notice was issued, they have not appeared.
In Supreme Court also?
Yes. And interim order is there.
Interim order to continue.
Item 30.
Till next date of hearing.
31 is a state appeal. But if we call it some other day, it will take some time.
September first week, at the request of.
Item 31.
So the university, the appellant matters against the direction to regularize these employees, daily wages employees, those who are working under the hostels.
Yes.
They were working in the hostel.
Yes.
So my humble contempt matters, the honorable single by.
How many years they have served?
They served some cases 5 years, 6 years, but that also that particular date they have not mentioned, and because they were engaged through that superintendent and the concerned authority of that in charge of the hostel. So that part also has not been taken care of. But mostly their appointments are made after Umadevi came into force, and their engagements were on daily.
Umadevi.
Umadevi. Their engagements were on daily wages basis, not against any existing vacancies, and not adapting to any recruitment process, or not paid from the salary, but from the contingency of the university.
And now opposite parties are on.
My learned senior is up there.
I am appearing for the respondent.
How much time is
It requires consideration in the light of Uma Devi and ML Kesari.
My lord, all the cases have been discussed by the Honorable Single Judge. And on the last occasion, my lord, when it was before the Honorable Chief Justice, he had requested the councils to file the judgment which was in this pertaining to university, which was confirmed by the Supreme Court. My lord, those judgments have to be filed. And I have filed the latest judgment of the Honorable Supreme Court that is decided on January 1st, 2025. That is Shripad's judgment, my lord. And the judgment which went to the Honorable Apex Court and confirmed pertaining to these non-mess employees of the university also I have enclosed, my lord. I have filed those judgments before this Honorable Court.
We'll fix a date and hear you, not today, because we have not seen that January 25 judgment.
Yes.
Has it overruled Uma Devi?
No, my lord, they have deprecated. They have said that taking the help of Uma Devi, you cannot justly deny the rightful employment of the people. That has been discussed, my lord.
But any selection took place in this matter? No selection process?
They are super. My lord, these are of the university, my lord, sweepers, gardeners, malis, and watchmen. And they have from 7 years to, my lord, 20 years they have served. And now, by this time, all have completed 10 years. So therefore, my lord, now the university, only the court has held that relying upon Uma Devi case, my lord, that it is only irregular and not illegal. And they have given a direction to scheme, my lord, to form a scheme which is already there.
Well, sir, we'll fix some date. We'll take up that matter second week of September 2020. Bye. Okay. Next.
Gratefulness. Item 33. Item 33.
This is the order minus.
Mahapatra, where is your colleague? You answer this matter? Union of India.
One kindly see the last order that.
Some short matters we can take because I have another special bench.
But this is a very short matter, if your lordship will permit me, that this is a writ appeal, my lord. That's the person who is a constable, my lord, he was on leave due to his illness, and that leave was granted by the authority. Thereafter, he was hospitalized, and they treated this period as unauthorized absence. So my case is that, my lord, this is not a willful misconduct because of the my lord senior on VC, my lord.
Yes, sir.
My associate is in the court, but it's required full-fledged hearing. That's why keep it Monday, Tuesday.
the last week of August at the request of London Council appearing for.
My lord, this is out of always praying for time, my lord.
But Apex Court said,
I'm saying it is my lordship's bench is next bench is there.
My lord, last order, my lord, let's see everything.
Let us see. Apex Court here. Two judgments are against you. Just look into them. Yes. For military personnel, paramilitary.
I have come up with two judgments which are referred in this case.
This is explained. You are hospitalized.
Yes, my lord, that they have taken into consideration in the
They say you should have gone to the designated hospital.
They said that you have not moved to the our group hospital.
No,
which is that is standard only.
It's only
bullet to be removed in that hospital, nothing else.
No, the patient's prerogative. It's a faith that heals, not the medicine.
Yes.
Therefore, the hospital which generates faith in him, to that hospital he will rush into. That's how courts have held. Any judgments in that regard?
Yes, my lord.
Be ready with your judgments.
Yes.
On the next date you give us. Yes.
Item 37.
Your Lordship, item 30.
One.
Government appeal, my lord.
General appeal not possible.
I am for the response. Three more matters are there.
42 urgencies, but it is at the end.
42 are there.
Last page, personal appearance we have taken up.
We have finished it.
Last page report added. So, only one matter is left.
44, 46.
44, 46, 47, 41. See, all are here.
All are here.
44 should remain because it is 2016 one.
44 minus. Lordship, beg your pardon, I mean 44 minus.
44 we can. 44, call 44.
I mean VC minus.
So, Fonda, you take you take a date for 41. Government criminal appeal.
Except Tuesdays or Thursdays.
It's a writ appeal, my lordship. It's a writ appeal, my lordship.
Who is Sir Rautre?
Say appointment relating to the Shiksha Act.
Similar matters have you posted? Similar matters.
It's a individual matter.
This is separate letter.
Individual.
Yes.
24. 12th of August.
Sorry?
You want it earlier?
No.
Maybe pardon,
Yes,
make a mention. There's a review application pending before this.
Before this bench only?
Yes, my Lord Justice G.SATAPATHY was
this bench is constituted by Honorable Chief Justice. So you have to move the Chief Justice's office. We can't. We are a different bench. It's a special bench.
Right.
Not regular bench. Yes.
Item 1.
Yes, Mr. Mukherjee.
A judgment was delivered by this Honorable Court on the 24th of June 2024, which is at page 9 of the brief of my application. If your Lordship takes, important is paragraph 5 at page 11.
Can you give a brief thumbnail description of the order?
Yes, Manoj.
Yeah.
Now, what has happened is a consent order was passed on the basis of a series of judgments delivered by this Honorable Court that a tender cannot be cancelled. Once a person has been shortlisted or declared to be L1 and a tender is recommended in his favor, it cannot be cancelled without giving reasons, one. Second is without affording an opportunity of hearing to him. There are a series of judgments on this point of this Honorable Court. Now, following that judgment, this judgment was delivered where the petitioner had emerged as L1 bidder, and his case was recommended, but no steps were taken to issue the work order in his favor. And thereafter, what they did was they cancelled the tender and floated a new tender at a higher rate. Now, this was assailed by the petitioner, Malaj, and this Honorable Court vindicated his stand by cancelling the second tender and directing that the first tender should be completed. The work order should be issued. And there was a time given that this exercise be completed within a period of 3 months, because 3 weeks, sorry, Maharaj, 3 weeks, because your Lordship knows that in all tender matters, time is, of course, an essence of the contract, and there is a price escalation which also vitiates deep.
Yes.
So despite this time limit given, the order was not implemented. Hence, the contempt application was filed. Your Lordships may straightway come to the show cause, which the state has filed.
Page number?
Page number 4 of the show cause.
A running page of your paper book?
Sorry, Manoj, I don't have the running page. It's a show cause filed on the 7th of May 2025. Filed by show cause affidavit filed by opposite party number 2.
Okay. Scroll there. I should learn to shift to this IT level now.
I am also
I'm completely illiterate.
It's a flag B, Manoj.
Page 4. 18. Para 8. Page 8.
Page 4.
18. Perhaps running page 18, para 8.
No, para 7.
Para 7.
7.
Para 7, yes.
Go 18.
As your Lordship's got that page?
And internal page 4. Page 4.
Paragraph 7.
The Lordship may take from para 7.
In persons of order number.
But in persons of the order number 10 dated 24/6/24, that's the order which I was referring to, of the Honorable High Court of Orissa in WPC number so-and-so, Works Department with approval of the government had decided to go for SLP, before Honorable Supreme Court of India challenging the order so-and-so.
This was filed which date?
This was filed, my lords.
No, this statement was made on which?
On the 7th of May 2025.
7th of May 2025. Any SLP is filed now?
No. Till date, no SLP has been filed. Subsequently, they go on to say that we will file a review. We will. They have not yet filed. That review has not seen the light of the day. The law is well settled on this position, Your Lordship, from 2000 Supreme Court, my lords.
Very object of fixing the timeline for performance, as rightly Mr. Learned Senior Advocate said, because prices will shoot up. The rupee value is dwindling day by day because of several factors. That is the reason why this has been done. Thereafter, what efforts you have taken to file the SLP, to file the review?
Yes, sir.
Endlessly, in contemplation of your proceedings, can we postpone implementation of the order?
No, I only seek, my lord, I have to obtain an status of whether any review or SLP has been filed and whether the order has been stayed or not. If that is not done, we totally concede. My lord, we will comply with it.
You are certain by phone. No time, this is a special bench. for ascertaining that, because we sent the list yesterday. You should have ascertained by now. We can't do that way. It's a special bench. Government spends 2,000 rupees per minute of every bench. Going by CAG report, 2,000 rupees per minute for us. The entire staff, etc., so many, including. Therefore, you ascertain that. Now tell us. You can call from here only. We permit you. You ask them. Had they done that, they would have informed you, saying that learned AGA, we have already preferred.
There is no notice.
We are going to prefer.
There is no notice in the file also.
There is nothing like that.
Year has gone by. More than a year has.
You want to implement, or who should implement that order?
The order is to be implemented by the opposite party number one.
Party number one.
Yes.
Have you, in the contempt proceedings, have you made him a party nominee in personal capacity? In contempt proceedings, you have to make them nominee.
Yes, Maharaj. Yes, Maharaj. The commissioner by name. The commissioner comes Secretary Works Department, Government of Orissa. He is by name implemented.
No, two will implement the order.
Two is also by name. So
by name,
whoever is to implement.
So are they just go and verify? Are they going to implement, or
will implement
we do something?
1 week time will implement. Because there is no review, information is coming.
He says we'll implement it in 1.
Because my lord, there is no statistics available.
That's what. But if you want to speak to your client, you can speak and come back. Yeah, just verify. Go and speak. Because you should not take personal responsibility.
That may take a second item.
Yeah, in the meanwhile, we will take up second. Yes. Kindly wait in the court. Yes. No.
Item 2.
If they don't implement the order, what is the procedure? Arrest and detention, or any something? But again, jugglery, circus takes place.
Here, what is the thing? It has been bad.
Whichever like that.
But if not implement by the time.
Item 2.
Nobody will care for the court orders. Yes, sir.
I filed an IA in this REIT application number 25464 of 2022, which has already been disposed of for kind consideration of Annexure 7.
Annexure 7.
And with page number 8 of my IA.
Go to page number 11.
Nothing may be noted. Nothing may be similar. Without consent, they have filed the present application.
The petitioner has approached me and taken an oath under oath commissioner with an affidavit which I have been filed. If my learned senior is disputing, I would like to withdraw my power.
You want to object to his
Madam, what happens after REIT was allowed? MCL has gone to
you want to appear for the same party?
Madam, he is not coming, not approach the without any approach.
Your Lordship, let me clarify what happened. The petitioner previously, my learned senior was doing the petitioner's case.
In the council, even for the review petitioner, you were appearing.
Madam, even a contempt petition is pending where we have filed contempt non-implementation order. In the meantime, I have informed that they have implementation already order is implemented. Now that contempt is pending. But now in present case, without taking consent, they have someone has filed.
The petitioner has made an affidavit under the oath commissioner. If my learned senior is disputing that, I would like to withdraw my power.
No, generally, in a dispute of matters, if you want to seek modification, review, ordinarily, the same lawyer should appear. Because he will be knowing what happened in that matter. Any fees are to be settled in your favor.
Madam, that is settled due to non-compliance of that division bench order. Contempt is pending. We have filed contempt. Contempt, they have been so in the meantime they have filed a compliance appeal. We have to file a reply to that contempt is pending. now first time surprised to know this.
But your client has authorized.
No, madam. No, madam. No authorization. No, they have never come to chamber and.
How can you?
I'm appearing also contempt is pending.
All right, but you ask your client that.
I today morning I have also a ring, but the ring is continuing, but no one has responded.
Who has sold to the affidavit? Whose affidavit it is? Let us see.
Will come.
Whose affidavit?
The petitioner's affidavit under Oath Commissioner.
But I see my mobile today morning. I also contacted, but there is no.
What if the Oath Commissioner has said?
No,
under the Act, the Oath Commissioner, if Oath Commissioner says that he is presumed to be true, give that. No, how can you oppose?
No one has come to the chamber and we have not given consent. They on the other hand, contempt. We have filed contempt. Contempt is pending. Contempt petition is pending. That is a.
You said it about 3 times now. We have understood. But how can, suppose if the client comes and gives the affidavit to him, is it your case that he has fabricated that whether your client is here?
No, my lord.
No, what happens? Simply division allowed our 8%.
Whatever it may be.
That is another.
Authorized your friend. How can you object to that?
Without consent, they have appeared.
Without that question arises.
If I am lead to manner, so that is the authentic manner. So what appropriate manner would decide? We have object that so that manner should consider.
Do you see that your client has not given this affidavit at all? This is a false affidavit.
I have no concern. I have no knowledge.
Whether original,
I have no knowledge.
Then you need not worry about it.
I have no knowledge. Today morning I have also ring.
Anyway, he is an minister. Whether you know the procedure, that this is the affidavit which he has sold to.
Yes.
The client has sold to this affidavit.
Yes, your lord. Yes, lord.
You are sure of that?
Yes, your lord.
So who has identified that litigant? The swearer of the affidavit.
Myself.
You identified?
Yes, she had come to me. So I instructed.
She has signed the Oath Commissioner's register?
Yes.
This date and other things you have not filled up at all.
Yes.
That's their copy.
It's a copy.
When originally says. Yes, what you want to do with now?
Now I just want to.
You want to do what?
I am appearing from the opposite party.
Opposite party?
Yes. Matter has also come to its finality. We have preferred the SLP. Thereafter, they have filed the contempt and we have filed the compliance affidavit in the contempt.
You have filed compliance affidavit?
Yes, ma'am.
What was that direction?
Direction is for giving service to the petitioner.
Compassionate appointment.
Yes.
Compassionate appointment.
Yes. Not
rehabilitation and
rehabilitation.
Where some land was taken, something disturbed that way. Okay. Under the rehabilitation scheme, you got the employment.
Yes.
She got the employment.
Yes, madam.
Now what she wants?
I don't.
She wants to transfer the employment to her son.
Employment is not estate.
Your lordship, but after this writ has been ordered in her favor, then MCL has gone to SLP. Then it was dismissed. Then contempt was proceeded.
Correct.
After that, she wants instead of her son may be.
It's not negotiable. It is the appointment order is not negotiable instrument.
Your lordship, it's so I leave it to mercy of the court. Consider
the short point that arises for consideration in this application is
whether there is any provision in R&R policy for transfer of the employment.
It cannot.
It cannot. That's right.
It cannot be.
So how can it be?
It's not a negotiable instrument.
No policy is available.
You know, but otherwise everybody would have sold the appointment orders, depending upon the age.
It's upon the mercy of the court.
The short point for consideration in this application is as to the negotiability of an order of appointment issued on the basis of compassion under a particular government scheme. First off, learned counsel appearing for the applicant submits that she wants to transfer the appointment in favor of whom?
Her son.
Her son. First off. that is very difficult to agree with. In as much as already we have said, the transfer order is not a negotiable instrument. First up. Next paragraph. To our specific query as to whether the transfer is learned counsel appearing for the applicant in all fairness concedes that there is no such provision in the scheme. First, in view of the above, application is rejected.
I appear.
This will be PS for opposes. Yes, Mr. Mukherjee.
Item 1.
Government advocate in that come. The appointment, such appointments are personal to the individuals to whom they have been issued. Okay.
Yes, we have checked up the database. It is not available. No review, no SLP. Grant us to 7 days time, we will comply.
But by now it should have been complied.
But somehow after filing the so-called affidavit, we have explained the position. Perhaps
1 week we shall grant you. Next date we shall direct his arrest. Who is the principal secretary? Who is the?
No, that is the engineering chief, my lord.
Engineering will direct his arrest. Will direct his arrest and detention. With that, subject to that, if you agree, then we will.
That is your lordship discretion. Your lordship pass that order. That should be there.
Otherwise, they will not comply with it.
Otherwise, they will comply, but that Raigad should be there.
This contempt petition, please be seated, alleges violations, willful violation of the order dated so and so, rendered in complainant's WP number so and so. First, the said order had prescribed the timeline of 6 weeks for implementation. 6 weeks earlier?
Yes.
3 weeks for implementation. First, obviously, such a prescription of time period was after hearing the party, and it figured in the final order itself, regard being had to a host of relevant factors which court can assume. First, next paragraph. Non-implementation of writ of the Constitutional Court will not augur well to the rule of law in a state governed in a constitutionally ordained welfare state. First, the authorities are bound to comply with the court orders in a time-bound way. First off, if they have any justification for not obeying the court order, that has to be pointed out to the court. First off. Next paragraph. Learned senior argues, learned senior advocate Mr. Mukherjee appearing for the complainant. Next paragraph. Learned AGA Mr. Panda, in his usual style of fashion, submits that the contemners are contemplating an SLP to be filed in the apex court of the country against the order whose implementation is sought for. Alternatively, they are also planning to file a review petition seeking recall of the subject order, and therefore there is delay in being proved in the implementation aspect. First up. The next paragraph. Having heard the learned counsel for the parties, we notice under having perused the petition, the complaint papers, we notice that the order of the writ court was passed on. Which date it is?
24/6/2024.
Please be seated and say 24/6/2024. Fixing a period of 3 weeks for compliance. 7. More than a year has lapsed since then, and still the non-compliance stares at the court. First one, this is not a good thing to happen. First one. Next paragraph. When we threatened the contemners of legal action for non-implementation, which obviously would be very serious, learned AGA, in all fairness, undertakes on the instruction of his clients that the subject order would be implemented and compliance would be reported to this court within 10 days. Within 10 days. Very reluctantly, we agree with this because the complainant side also inevitably agrees with that. First, in view of the above, these proceedings are dropped with the warning to the opponents that non-compliance would tantamount to aggravated contempt and may attract arrest and detention, in addition to levy of thousands of rupees personally payable by them by way of courts. First, this apart, an adverse entry may be made, may be directed to be made in the service register records of the concerned officials. With this implementation happens. This is the way. Unless we threaten like this, they will not implement at all nowadays. Why governments have become like that? We do not know. Nobody cares.
Sanctity of 226 is being eroded at the process.
Sanctity is reinforced by these kind of orders.
Should come to that.